Estate planning can be confusing, and I get questions a lot about how does an estate plan differ from a will? And so I want to address that question here in this video. So estate planning, if you're unfamiliar with that term or concept, it can be confusing. If you've never done an estate planning, if you've never been around people that talked about estate planning, it can be confusing. Some have never heard of that phrase, estate planning, but some of you at least heard of a last will and testament, right? I mean, most everybody's heard of a last will and testament, maybe even a power of attorney. Um, but you may be wondering, so if I have a will, that's an estate plan, right? Not really sure what it means. And so to clear up some confusion and help you understand the differences, let's talk about the importance of having an estate plan and explain how a last will and testament fits within an estate plan. So an estate plan is a comprehensive set of documents and strategies to manage and distribute assets during your lifetime and after your death, and to prepare for unexpected life events that may cause you to be incompetent, incapacitated, or for some reason not able to make your own choices and own decisions. Sometimes you may be not just able to verbalize. You may be on a ventilator or something. So estate planning encompasses all that. The planning can be a collaborative effort between your lawyer, accountant, financial planner, financial advisor, because we want to structure the best legal strategy and financial strategy for you. For my purposes as an attorney, it's the legal strategy. For purposes of this video, I'm focusing only on the legal side of estate planning and not what your accountant or financial advisor can provide to you. So what is the purpose of an estate plan? The purpose and the importance of an estate plan is it allows you to make the decisions while you're able about the disposition of your assets at your death. That is, you get to decide who gets what. So while you're able to make the decisions, you need to do that now. More importantly, you can appoint guardians for minor children to ensure that if you are unable to take care of your minor kids, in Alabama, a minor is under the age of 19. If you were to pass away or something happens to you, like you're incapacitated before they turn 19, you get to direct who you want to be that person that raises them or takes care of them while you're incapacitated. So a will and estate plan allows you to designate your guardians. An estate plan allows you to be in control of all those decisions and allows someone of your choosing, yours, not a court, some of your choosing, to conduct your business and legal affairs if you're unable to do so yourself. If you don't do that ahead of time, if you don't have your estate plan together, then a judge who doesn't know you, doesn't know your family, doesn't know anything about you or what's really best and what your wishes are, the court has to step in and make those decisions and name those people and decide on what happens. So what are the three major components of an estate plan? Well, there are three major components. And we do this in every estate plan in Alabama. One is a last will and testament. Two is the power of attorney, and three is the advance directive for healthcare. Now, those are just the basic documents that should be a part of every person's estate plan, regardless of your net worth, whether you have $5 or $5 billion. You need to have these documents in place. There are some people who may not need a will. I will admit that, depending on how your assets are structured, but you don't know that until you talk with a lawyer about it. However, it is best to have one and not need it than to need it and not have it. An estate plan may also include a trust. Not every estate plan will, but there are circumstances where that is best. Once considered only for wealthy people, trusts have quickly become a favorite tool of my clients, regardless of their net worth, because it's an easier way to transfer, usually it's an easier way to transfer property after death. A trust will likely be needed if you have young children and are special needs, minor or adult child, just because there are better ways to manage and distribute assets that way. However, whether or not you need a trust or a benefit from a trust must be determined after consulting with your estate planning lawyer, such as me. All right, what is the last will and testament? So this is one of the major components of every estate plan. The last will and testament is a legal document that directs, per your wishes, who inherits your assets, whether it's personal property like jewelry, furniture, art, clothing, those type of things, or real property like your residence, or maybe you have a vacation home. It gives you control, excuse me, it gives you control of who gets all that you have accumulated during your lifetime. So again, this goes back to the control element. While you're able, you can designate who gets your assets upon your death. You can specify which assets go to whom, such as family members, friends, charities, organizations. Don't forget the charities. If you're charitable during your lifetime, you may want to give to charity in your death. You can intentionally exclude someone from inheriting your assets as well through the correct verbiage in your will. And this requires, if there is someone you want to exclude from inheriting, you must talk with an experienced estate planning lawyer to do that, because there are certain ways to do it and certain ways not to do it. If you did not have this document, talking about the last will and testament, then all your assets would pass pursuant to the state's laws. So even if you don't have your estate plan, you haven't done your own, the state has one for you. And if you saw a blog that and some videos I posted in the past, you don't want do you really want the state legislators to tell people what happens to your assets? I don't think so. Perhaps you may be estranged from a child or you want to give money to charity. You can control those things through your will. But if you don't have a will, that child will still inherit. Or if you don't have it drafted correctly, that child can still inherit, and that charity is going to be out of luck. So if you have young children, the last will testament can name your guardians. It can name that person who's going to raise your children if you die. It could also designate if you don't want someone to inherit, and it can also designate money going to charity. Those are things that you can control by doing your last will and testament. These are all crucial decisions that have to be made. And you don't want to leave that to a judge who doesn't know you and doesn't really know what your wishes are, what's going to truly be best from your perspective, what's truly best for your family. So when do you need to make an estate plan? Well, now, yesterday, regardless of your net worth, if you are over 19 years of age, you need to have an estate plan. And again, the estate plan is that total package, that total plan that includes the power of attorney, the last will and testament, the advance directive. Many of us don't want to think about, much less talk about, our eventual death. I mean, it's just kind of morbid, right? We find it morbid, scary, and emotionally charged, particularly if we have young children. I've had so many moms cry with me over the thought of not being there while their children are growing up. The reality, though, is we can't predict what will happen or when it will happen. We all know we're going to die, but we don't know when. We can't control that. And so we can't control the other driver on the road. We can't control that hidden aneurysm or the undetected cancer that's growing and spreading in our bodies. But you can control your estate planning and what happens to your assets. Failing to have an estate plan, even if you have just a few assets or low net worth, can cause conflict within your family and an extraordinary amount of money and time by your family to gain access to your bank account, transfer your house, or do all those other things to transfer your assets and take care of those things. Things don't happen generally automatically. There are a few things that transfer automatically, but it's limited. So failing to have that estate plan in place is just going to cause conflict, chaos, more work, more hassle, more stress, and much more money paid by your family versus you doing an estate plan now. We all know the reality that something can happen. You know, how many times you said, if something happens? We all know the reality that something can happen at any moment. Our head tells us that, but too often our heart just doesn't want to deal with it. We can't deal with it a lot of times. We tell ourselves we'll get to it one day, do one day in quotes too, without accepting that one day may be one day too late. Saying it rather than speaking it out loud, rather than speaking out that estate plan, suppresses probably sugarcoats is the better word, the reasons why an estate plan is needed, as if not saying estate plan will somehow protect us from our eventual death. We don't like facing our mortality or our vulnerability, do we? So we don't want to talk about it, but it's a must for anybody. An estate plan is an overall strategy and set of documents to manage and distribute assets, whereas a will is a component. It's just one document of the estate plan. So that's what the difference is between a will and an estate plan. So I hope that's answered that question at least. If you are ready to do your estate plan, then reach out to me. I'm Tanya Hendricks, Huntsville Estate Planning Lawyer, and you can reach me at 256-361-1221. That's 256-361-1221. And my website that you can actually schedule directly a consultation from is HuntsvilleEstatePlanningLawyers.com. Again, you can go to my website, schedule the consultation straight from the website. And that website is HuntsvilleEstatePlanningLawyers.com. Thank you and have a great day.